This bill will soon be an effective legislation from the date of its enforcement in official gazette. We all know that using internet is no more a luxury. At the same time, it becomes an integral part of our daily work. Also, considering that government of India has been focusing on digitization, which is evident from its efforts in the recent past, which makes it all the more important for India to have a legal framework to regulate personal data being communicated over digital mode. The law indicates that the lawmakers have been quite strict on putting a lot of obligations on the data fiduciaries, that is, the persons who collect the data. Now here, it is important to note that the term person includes individuals, companies, HUF, state, association of individuals, body of persons, firm, almost everything. Under the law, there is a mandate for the data fiduciaries requiring consent of individual from whom the data is to be collected to send a formal notice to tell them, inform them that this is your personal data, this is the purpose for which it is being used, this is the mechanism for withdrawal of consent with ease, this is the grievance redressal mechanism. This requirement of obtaining consent and sending the notice is equally applicable on the consent which is being taken by the data fiduciaries from the data principal even before the commencement of this act. The act also requires data fiduciary to take reasonable security measures or practices or safeguards to prevent personal data breach and delete the data once its purpose is fulfilled. In case still breach happens, the data fiduciary is under an obligation to make an intimation to the Data Protection Board of India and also to the data principal, that is, to whom the data actually belongs. Needless to say that the data which is being used or collected within this framework has to be used for the lawful purpose, that is, for the purpose for which consent is being sought from the data principal. The law puts an obligation on the data fiduciary to make readily available the grievance mechanism which is required to take care of the non-compliance or breach in relation to the digital personal data. There is a need and a requirement from the data fiduciary perspective to promptly address the concerns of the data principal, if any, and that too within the time which is stipulated once the rules gets into picture. In case the concerns or the grievances are not properly addressed, complaint can be raised to Data Protection Board of India. Of course, there are appellate provisions as well under the law, which means an appeal can be preferred within 60 days from the date of receipt of order pronounced by Data Protection Board of India. The Act provides protection to digital personal data which is collected in India or outside India, either in a digital form or non-digital form, which is digitized subsequently. Yes, it is possible. However, under the Act, central government has been empowered to issue notifications to restrict transfer of data, or rather personal data, for the processing of data in certain countries. Well, the Act levies different penalties on data fiduciary in case there is a failure on their part to meet the compliance requirements. The monetary penalty under the Act may extend to INR 250 crores, of course, after disposal of related inquiry.